Hey. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the fourth Commonwealth. Your name and your tendency shall be heard. Now sitting in Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the Appeals Court. I am William Mead. With me on the panel today for this first case are Justices Rubin and Hand. Each side gets 15 minutes of argument. Please pause if the justices have any questions for you. There is no rebuttal. You needn't use all of your time. With that, I'll call our first case, 21P 1072, Kelly versus the Commonwealth of Massachusetts Department of Conservation and Recreation. Mr. Kelly.
Good morning, Your Honors. If it please the Court, Joseph Kelly, plaintiff appellant, appearing pro se. The introduction to the Superior Court model jury instructions reads as follows. These model jury instructions are intended to be just that, models. Judges have broad discretion and inherent authority to decide how to instruct a jury, whether it is by adapting these models, crafting their own instructions, or starting with some other model. Employment attorney Rob Mantell authored a Mass Bar article entitled "The Misplaced Expectation of Close Timing in Retaliation Cases," which makes clear that any inference of a break in the causal link over time is contrary to human nature and contrary to how Chapter 151B was written. A related article, also authored by Mantell, entitled "The Liberal Interpretation of Chapter 151B," makes clear that the timing instruction as worded was not only faulty, but as a matter of law contradicted the clear intention of the legislators. Borrowing from this article, General Law 151B subsection 9 directs that it shall be construed liberally for the accomplishment of the purposes thereof. The legislator did not wish to leave the courts free to apply vague and shifting principles. Rather, they chose to enshrine a single guidepost for statutory construction, the requirement of liberal interpretation. It is the obligation of courts to provide instructions outside of the pattern instructions, which cannot infer possibilities outside the margins of a specific case.
So you requested a specific instruction as it related to seasonal work?
That's correct.
Okay. And did the judge, he didn't give the instruction at all or something, a variation on it?
He did not change the instruction at all.
Okay. And had you submitted that instruction in writing, the request?
I did at pretrial.
And when the judge didn't give the instruction, did you lodge an objection?
Yes, I did.
Can I ask you a question, Mr. Kelly? I know it's difficult being a non-lawyer and arguing before us, and I should say you've done an excellent job of presenting your case for a non-lawyer. I think we understand it. Let's say I were to agree with you that you preserved your objection to this instruction on temporal proximity. Well, at least to the part of it about immediate action, the immediate aftermath, the first part. I didn't see an objection to the second, the part at the end about a long time may negate or may defeat the inference. I didn't see any discussion of that, but I did for the first part. Let's say I conclude that that preserved your claim of error. Your opposing counsel argues otherwise, but let's say I find that. And let's say I look at it and I say, well, this is a misleading instruction in a seasonal work case. It shouldn't say that at all. I don't know why the judge gave it. That seems wrong to me. That's not what the jury should have heard. For you to succeed, though, I still have to find that that instruction played a role in the jury's deliberations. Of course, who knows? We're not allowed to even, right? I mean, it's just, we're not there. We don't know what actually played a role. But we look at it objectively. Tell me what I'm seeing wrong here. It seems to me that in order for that instruction to be relevant, or the error to be relevant. Maybe it should have said, of course, in the case of seasonal employment, immediacy may, you're not to examine the immediate temporal reaction when they aren't together and there's no opportunity to retaliate, and, and so on, right? The jury still would have had to find that the defendants were retaliating against something you did 54 days before the end of the season where they were all there together. So you were there another 2 months, and the act of retaliation didn't occur. And during the 2 months, you even damaged, under whatever circumstances, some property at the place. And if they'd wanted to cook up a phony scheme to get rid of you, surely it would have been quite easy to write down, damage some equipment, don't rehire. And they didn't do that. And they could also have, with or without that, they could have said, instead of rehire, they could have asked, we have some concerns, there's something, and you maybe wouldn't even have been called in. The jury has to find that all of that was part of a secret conspiracy to wait till the next year to retaliate against you, and not even to do so by just not rehiring you or not calling you for an interview, but by having you in, and then at the interview, after interviewing other candidates, to not choose you.
Yes.
And what I'm wondering is how likely it is that that's the way people retaliate against someone who has reported sexually inappropriate language to their supervisor.
Sure. We have an experienced supervisor, 30 years with DCR, who certainly should have known that, well, he admitted that he knew that there were sexual harassment officers. So on July 3rd, when he failed to report my sexual harassment complaint, he did nothing, which led to a much more offensive remark on July 7th, where I complained on July 7th. And then he, according to his notes, he says that there was only one complaint on the 3rd, but what actually happened was there was a complaint on the 3rd, and then one on the 7th, then he talked to Jeff Culloden. But if one to believe him, he acknowledged that there was remarks about my complaint of a 33-year-old man talking about masturbation and rape in front of young ladies. And then he waited 4 days before talking to Culloden. He did not call Culloden. He did not talk to him. He didn't ask another supervisor to talk to him. And worst of all, he didn't report it to the sexual harassment officers.
That's all fine.
Right.
But he also didn't, after some equipment was destroyed, create a pretextual reason for not recommending you for rehire. Could have done that. That might have looked better than this, right?
Actually, Justice Rubin, what that would have done is it would have opened Pandora's box to file. They're looking for a pat on the back for not filing false accusations against me, which would have opened the door to, hey, by the way, we have this other situation that's still not dealt with. And also, when we go to the end-of-season performance evaluation, there again, if they had said, no, we're not rehiring this person, if you look at the bottom of that document, it says that I would have 30 days to request a hearing, which again would have opened up Pandora's box on this issue. So an experienced 30 years with the agency supervisor said, hey, let's stretch this out. Let's game the system in order to stretch out the perceived amount of time between the two events. I suppose if there was 1 year of continuous employment and there was a protected act and then an adverse action, one would have to look at what happened between those two events to see what might have happened.
I'm not saying that your story shouldn't have gone to the jury. Look, I'm not saying that. I hear everything you're saying, and I have been doing this long enough to not be surprised how people behave. So I can't say that's for the jury to decide. But what I'm saying is, how likely is it that a jury with all this evidence in front of them said to themselves, oh, the critical issue is the interview and how that was treated. Oh, but I see this instruction, and the reason I'm not drawing the inference from that is because it was almost a year later, or whatever it was, 8 months, 9 months later. What's the likelihood that that's the way that they were thinking, rather than looking at the earlier opportunities and maybe not buying, that these apparently quite incompetent people somehow were able to cobble together this genius plan to be able to retaliate against you, but to do so and not get caught?
Sure. If you look at my brief, it does explain that I reworded, and if you look at my pretrial submissions, it just worded that because it's absent any other components, and I listed about 20 different components, and all it took was a couple of jurors to say, no, look, it says it right here. It says that it could, and without even giving a specific amount of time, it said it can break the causal link. And it doesn't, it's not a matter of law.
That's the second part of the instruction. It's the immediate thing at the first part that you objected to. So that's the part I'm focused on. Although I think the second part of the instruction might be wrong, you didn't object to the second part, you objected to the first part.
What I was referring to was Judge Green's explanation in the summary judgment, where even DCR was unclear about how that timing issue came into play, and Judge Green had to clarify it and say, no, due to the nature of seasonal employment, that timing issue was not relevant. Now, Judge Hagan said, well, I could mention it in my closing, but as we all know, that's not a matter of law. Plus, if I had to explain how the law applied to my case, I certainly would need more than 30 minutes to do so.
But neither you nor the department made any reference to that time break. Is that correct in your closings?
I don't remember what DCR did. I know the draft jury instructions came in at 11 p.m. the night before the charge hearing. So I had very little time to catch what I did catch, and thank God I did. But I had remembered, wait a minute, I mentioned this. I did my pretrial submission, which was quite clear. But I cannot instruct the jury on how the law applies to a given case. That's what the Bible is for. That's what those jury instructions are for. And I see we only have a couple of minutes left, and I would like to address the Jeannie Kelly lawsuit as well. The parallels between the two. The judge even mistakenly at the charge hearing thought that Jeannie Kelly's case was a sexual harassment case when it was purely a retaliation case. And that the exact same three sexual harassment officers were involved in that case. They had an intimate knowledge of what would happen and what could happen, and to game the system to extend that length of time would certainly work in their favor.
What exactly did you want to do with the evidence from the Jeannie Kelly case? What is it you were not allowed to do?
I wasn't allowed to bring it up at all. And that spoke to an extraordinary motive to make sure that my complaints never saw the light of day.
Did you cross-examine Jeannie Kelly herself?
I'm sorry?
Did you cross-examine Jeannie Kelly?
No, Your Honor. The subpoena was quashed.
Jeannie Kelly didn't testify?
No, in limine, it was...
Oh, I see.
Yes. Now, and if you look at DCR's motion in limine, they just cited generic prejudicial versus probative value argument. And by the way, in their brief, they actually said that the judge found it to be overly prejudicial. The judge never said that. The judge just said he did not want to take time to retry the Jeannie Kelly case. But if you look at my opposition, my opposition clearly cites 6 cases that are employment law specific that apply to the admissibility of their past failures.
Are they all Massachusetts cases that you're citing?
Yes, yes, Your Honor. So, I believe that fear of retaliation is why most sexual harassment goes unreported. I think that people who have the courage to stand up and look and report a supervisor, to have that courage, should be protected under the laws of 151B. Bystander retaliation especially, I hear all the time with the Me Too movement, well, where were you when all of this happened? And of course, I was present, so if anything happened, if the young ladies went to their parents and said, hey, you won't believe what my supervisor just said to me.
Your time is up.
Yes, thank you. And with that, I rest on my brief. Thank you.
Ms. Vail.
Good morning, Your Honors. Hannah Vail for the Department of Conservation and Recreation. Plaintiff's arguments regarding the temporal proximity instruction should be rejected for 3 reasons. First, he's waived the argument. Second, the jury instruction as issued was correct. And third, plaintiff cannot show he was prejudiced by the issuance of the instruction. Plaintiff did not comply with the Rule's 51B requirement to state distinctly the matter to which you object and the grounds for your objection. And the purpose of Rule 51B is to prevent needless appellate review of issues that were never brought to the attention of the trial judge in the first place.
But this was brought up to the trial judge.
He did make general factual arguments regarding temporal proximity, and the judge correctly pointed out that this was material for...
Wait, say that again, the judge? Yeah, maybe move.
The judge correctly pointed out that this is material for a closing argument, not jury.
I don't see why that's right. That sounds wrong to me. Okay, so let's take the real example here, a better example. I mean, the jury instruction seems crummy to me, all of it. I don't understand that jury instruction. It says action taken in the immediate aftermath can give rise to an inference. If I have seasonal employment and the event takes place on the last day of my employment, and then I don't see you again for 10 months, and then I show up and immediately someone does something to retaliate against me, I think the inference is just as good as if I'd stayed there. I mean, not just as good, but a strong one. So to that degree, it seems to me the instruction is not right. The judge acknowledges that. I understand what you're saying. You can argue that in closing. Okay, so now we have closing argument, and Mr. Kelly gets up and says, I know it says immediately in the instruction, but it's just the same because it was, a temporal gap due to seasonality. And the jurors go back to the deliberation room, and one of them says, that Mr. Kelly, he made a very good point there about this thing. And the other juror looks at the instructions and says, yeah, but it says immediately after. Right? I don't understand how being able to argue it helps.
I think the instruction mirrors the SJC's holding in Mole, which says that where adverse actions follow close on the heels of a protected activity, a causal relationship may be inferred, and that as
So do you think it cannot be inferred ever in a seasonal employment situation?
No, I think it probably can be inferred, but that's a question for the jury. And
Yes, well, how should they properly be instructed so that they consider it properly?
I think that the instruction as issued was correct because it said temporal proximity when it's close may be an inference of retaliation, and when it's not, when there's a substantial gap, it may defeat an inference of retaliation. It's not determinative in any way. And I think, to your point earlier, this was not an immediate retaliation.
The inference may be drawn, the instruction says, if adverse action is taken against a satisfactorily performing employee in the immediate aftermath of the employer becoming aware of the employee's protected activity, or where adverse employment action follows close on the heels of protected activity.
Yes, but then
This was 10 months later.
Then the instruction continues and says closeness in time between a protected activity and the adverse employment action allows but does not compel an inference that retaliation was a reason. So there's a closeness in time.
I agree with that. It does not compel, but it allows. But in a seasonal employment, I mean, maybe I'm just repeating myself. I just don't, it seems to me there's a problem with this instruction, at least in a seasonal activity kind of case, a judge should fix it so that it covers the facts.
I understand Your Honor's point. I would say that that issue is not briefed in the appellant's brief. He instead raises an issue that he wishes that the language absent additional evidence should have been included. It's at page 43 of his brief. That language was not raised in the charge conference, and it's not included in his proposed jury instruction that he gave to the judge. And so the judge has not, this is not a highly technical bar that Rule 51B imposes. It says you just have to identify the language that you want added or changed or omitted. And plaintiff, in fact, did that on page 31 immediately after this exchange. He says, I would like legitimate added before every business-related instance in the instruction. And the judge says essentially no. And I think in that instance, his objection was preserved. It's not a highly technical bar, and it simply was not met. But even if it was preserved, I believe the instruction is correct and mirrors SJC's holding in Mole because it conveys that temporal proximity is a consideration for the jury to consider, but it's not determinative. We don't impose a bright line rule of where temporal proximity infers retaliation when it does not. That's a question for the jury to decide.
That would make a great jury instruction, what you just said.
Thank you, Your
That
Honor.
sounds right. It's a little different than what the judge said, but it's...
Thank you, Your Honor. A lot of plaintiff's arguments to me seem like an argument that the jury should have weighed the evidence differently, that they should have looked at the evidence and concluded that the gap in time was short. But the jury had the opportunity. They could have considered all the information and considered that the 2013 complaint and the 2014 interview, given the seasonal nature of the job, which was discussed extensively during the course of the trial, if not in closing, could have inferred that that was a substantial gap, and they clearly rejected that argument. And even if the jury instruction was not correct, plaintiff can't show he is prejudiced because there was ample evidence beyond temporal proximity that contributed to the finding, that could have contributed to the finding that plaintiff was not retaliated against by DCR. Plaintiff admitted at trial that he viewed the interview as a mere formality. He listed Ashland Park as his third choice rather than his first choice. All three interviewers, including one interviewer who had no knowledge of the prior complaint, scored plaintiff poorly and indicated that he rambled, that he seemed jittery, that he did not answer all the questions asked of him. Meanwhile, the person who was hired performed well during the interview, had more supervisory experience than plaintiff, and the other person who was interviewed also had higher scores than plaintiff. He was, in fact, the lowest performing candidate in the interview. And so the jury could easily have concluded from this that DCR simply hired the best qualified candidate and did not retaliate against Mr. Kelly. And I'd like to briefly turn now to the second issue on appeal, the Jeannie Kelly case. That case involved circumstances that occurred, I believe, 7 years prior to the circumstances in this case. It was a different conduct, it was a different location in DCR, different circumstances, all of which the judge pointed out. To introduce this evidence would be only prejudicial to DCR and would not be probative. And I think there's a significant risk of confusion to the jury where there's the same last name for two plaintiffs and you're discussing a case that occurred, 7 years earlier. And ultimately, this is a decision that's within the broad discretion of the trial court, and I think he acted within his discretion here. If there are no further questions, I'll rest on my briefs and I'll ask the panel to affirm the jury's verdict.
Seeing none, thank you. Thank you both.
Thank you very much.
We're going to take a short recess so the panel can be reconstituted.